start the conference. To moderate this session, we have with us Mr. Justin Thomas. He is with the Marine and Offshore Division in Bureau Veritas, Dubai. He has 30 years of experience in shipbuilding, ship repair and marine survey fields. Mr. Justin has been working with Bureau Veritas for the past 6 years and before that 11 years in Dry Docks World, Dubai. Sir, I request you to kindly join us on stage. A round of applause, please, ladies and gentlemen. Sir, I welcome you to ShipTek and request you to kindly take over the dais and proceed with the session.
Thank you, Sonia. Good morning and very warm welcome to the second day of ShipTek 2019. Our first paper is Port Liability Insurance. So, the speaker is Mr. Aftab Hasan, Risk Exchange DIFC Limited. Aftab is a professional entrepreneur with a resounding stake in energy, offshore, marine and oil and gas, IT and insurance and reinsurance sector. He has approximately 27 years of professional experience serving and leading top management team with leading companies from India and Middle East. He is an elected representative committee member and Secretary General on the Board of Insurance Business Group under the auspices of Dubai Chamber of Commerce and Industry, while serving on the board of various business groups, social and networking organizations. He has 2 bachelor degrees, one in science and another in engineering, a master degree in business management, diploma in strategic planning, mergers and acquisitions, and certification in quality management. I think we have got a right person to speak about this port liability insurance. So please join me in welcoming Mr. Aftab Hasan for the presentation.
Good morning, ladies and gentlemen, I should say, or gentlemen. I think there was one lady I saw. So ladies and gentlemen, of course. Normally, the second day, the turn-up which you see today in this international conference, this is surprising to me because still I have been attached with ShipTek from day one, and each year I have been giving the presentation in different topics. So I've been seeing always like facing the first day of the crowd, and today was the second day, and still people are there. So it means, yes, we can see the maritime sector and the flavor of the market within the line, I would say. The presentation which I'm going to give is more like understanding about port operators' liability. So we should understand like there's a difference between the port liability directly, which they take it themselves, and the liability which is covered by the operators who are running the port, with the likes of, let's say, DP World is one of the operators running like 6 to 7 of the ports in India as well as many other places. So what should they look into, the operators, and what should they cover, and where are the areas where the concern, what it should cover? Though the timing 20 minutes is not enough, even 60 minutes will not be enough, but I'll try to run this as fast as possible. And if you have any questions, or I will distribute my card and you can get in touch with us or my team. So, of course, the disclaimer is very important that tomorrow you don't take my advice in different tangent and pull me somewhere with my advice. So these are the presentation outline, which is the port operator's liability, covering various consequences and risk of loss immune to port operators, types of risks included to port operators, or liability of port operators from different scenarios, or ports and terminal liability insurance, P&I insurance, and conclude. So coming on the port operator's liability, the cover various conditions. As you know, the port, of course, represent very specialized and is in fact a complex risk area depending upon the business enterprise we are talking about, which varies in sizes and methods of operations, facilities, and many other areas. And certain loss exposures are common to almost all the ports. And in addition, many port losses exposures are of a type that are common with many other industries as well. So this is just a synopsis of what it is on the port, where the risk lies. So these are general, as I said, and it depends upon the size of the port and depends upon the operations and methodology of the port. So if we talk about the risk of loss, which are immune to port operators, are categorized in three general categories. And one is property loss, the second will be the liability, and the third is the personal loss, your personal, we'll say, assets or something which are related to the people, the staff there, or something like that. And the risk included in these three general categories, if you take it, are, again, now the bailment liability, the second one will be the contractual liability, and the third is pollution liability. And this is something of importance to understand when I say these are the liabilities. Of course, with the name itself, with the nomenclature itself, like we talked about bailment liability, so what it should cover? This covers loss due to negligent cause. Now, in the case of a port, it is mainly reflected by the warehouseman liability for damage to goods which are left in the ports, which you say care, custody, and control of the port. And since port typically have substantial, warehousing and storage facility, so they should recognize that a very large potential for liability exists, and then should property be damaged because of their negligence, they are liable. And if they are liable, so it means that it could go in the matter to the court, or should a dispute arises, this is called bailment. That will come into, that will trigger there. So let's go to contractual liability. As you see that two parties shaking hand, having a contract, and when it goes to dispute, there's a big line in between, so there's a dispute. Now, as a risk, contractual risk assumption, if I take it in consideration, or you can say that, or transfer of the contractual agreement, if it has not taken place or has not occurred under a wide variety of agreements, which can include like construction contract, whether it goes, or whether at the port there are, lease agreements, which if it goes, there are procurement which is done, so purchase orders, those contract, there are rental assets and units which are brought, so rental agreements sometimes do dispute. There are, some maintenance which are going on under the maintenance contract, so dispute can arise. Or rather, you can see that there are sometimes warranties which are given, those dispute under the contractual liability will come with the vendors, or sometimes mutual and mutual agreements or verbal agreements also sometimes, which it goes in the court, and contract of sales or charters, such as etc., I can give it to. So these all comes under the contractual liability. These are the dispute which often happen at the court. So now the third one is pollution. Of course, the picture is for illustration, just for this, that whenever you have exposure, and the exposure, especially we are talking about the pollution, may vary depending upon largely on whether or not a port handles or stores, let's say, a petroleum product or flammable product or an hazardous material. The volumes of such goods which are handled and the potential exposure they pose or the hazards they have sometimes is huge, and it triggers pollution and contaminations, and their pollution liability can be a gradual occurrence, which also you can say over a period of time sometimes, because there was a leakage from the storage, and so that also can trigger. So these are what I say, like, things which are in general the risks which are included to port operators. Now we talk about the liability of port operation for different scenarios. Now there is a scenario which is a joint venture liability. So what it covers losses due to disputes between two entities working as joint venture partners. And we all know, like, I gave some example of DP World, for instance, and this happens, like, the ports can become exposed to risk arising of activities of other partner, which is your joint venture partner, and when they participate in joint venture to the extent of the written joint venture agreement which are established, and those liabilities which are mentioned through hold harmless and indemnity agreement under that or insurance provision, these must, I should say, be reviewed and to determine that what the gamut of port liabilities exposures are, and whether that gives you a provision to defend yourself if it goes under that joint venture disputes and those liability which both partners they carry. They should always look into these aspects as well. And I can go on detail because of the timing. I will try to cover fast, and then that, as I said, any questions later I can take it. Now, if you are running a terminal, you have a terminal operator's liability as well, and the insurance normally, of course, will cover liability from the premises, hazard, and operations necessary or incidental, vicarious liability from the operations of contractor or subcontractors, and liability assumed under contract products, completed operations, personal injury, and the ownership, operations, maintenance, loading or unloading of watercraft. Now, like any other business enterprise, as you know that port is also exposed to losses, and from the existing of its premises or the operation which is conducted in the port by the different and various of the entities or stakeholders who are working on the port, and these exposure exist from, you can say, from bodily injury or property damage to the general public as well, or the visitors coming there. You can say about the contractors and their people, or others working at port facilities, or sometimes the vessels which operates at the ports and their cargo and surrounding properties. So this is something which is a responsibility of the terminal operators under this particular liability, that they are exposed and they should cover themselves. Now, every port has a stevedoring operation, and wherever you have a stevedoring operation, then definitely you carry some of the liabilities on your shoulder. In either case, either liability for losses caused by unseaworthiness of a vessel, and which should be contractually imposed on the vessel owner and not accepted by a port, for stevedoring contractors liability, because normally the stevedoring operation, let's say in Port of Fujairah and all, many places I have seen, there are contractors which have given the subcontracts to some other stevedoring contractors, So the liability is transferred, and they also carry the same liability, the main contractor, which is transferred. And it all has to be under the contractual transfer to the subcontractor via hold harmless wording. It has to be. This is the advice. Now, even it covers a port liability arising out of loading or unloading a vessels and moving goods, the liability for injury to stevedores, which attaches through a contract between the ship and a port, berth or terminal facility, usually which is governed by the term of the contract. And as a ship owner may enter into such a contract on a formal basis or a more informal basis, for example, where the use of facility is regulated by well-publicized standard terms and conditions. An operating port may or may not provide stevedore services directly. So stevedores may be employees of a port or hired under contract, as I said, with a stevedoring company. So these are the liability. Now again, going on, liability of ports operator for different scenarios. Also, one of the scenario could be wreck removal operation. And in this, in many cases, like the wrecks must be removed if they pose a threat to safe navigation or obstruct access to port or the port facility. And as you know that even the IMO, which has enforced on 2015 on 14th April, which was that as on date 10 states have ratified it, and those 10 states are Bulgaria, Denmark, Germany, India, Iran, Malaysia, Morocco, Nigeria, and then the UK. Now the convention applies only to wreck located in the member states, exclusive economic zones as well. However, a member state may choose to extend the scope of the convention to its own territory, including its territorial area. And this is the ships of 300 GT or more which fly the flag of a member state or use a port or offshore facility in the territory of a member state will be required to have insurance or other financial security in place to meet the liabilities arising under the convention. So this is governing under the IMO convention for wreck removal, and the registered owner, they will be liable for the cost of either locating or marking and removing the wreck, which constitute a hazard posing a danger to navigation or may reasonably be expected to have major harmful consequences for the marine environment or damage to the ecosystem, even coastline or related. And wreck includes any object, which we say, which is or has been on board the ship and then it went into the sea. We have instances like in Halul Island, the operators, they were asked to clean because when one of the ship which has sunk, which was 2 years back, and then it went into a dispute with the Qatar government there, and though IMO has to intervene and it was taken in the court, international court, this matter. So similarly, these things which I'm just trying to say that, these are the guiding factors for the operator they should often take care of. And again, for the towage operation as well, yes, for the towage operation as well, there are, we should take care of that two things which is very important. One is like the normal towage which you have, which is the situation when a ship is entering into or leaving the port and requires like the use of tug, which is for to take the ship to the harbor or towage contract, or with a local tug which they take it there. And then of course the second will be habitual towage, which is sometimes it is very unusual although for ships to be habitually towed from port to port or from place to place, but that is also there. So although it is is normal for ships to maneuver under their own power, but they often, as I said, need the assistance of tugs when berthing in port. So these are also circumstances where it warrant assistance of tug always, and then if even sometimes the ship is temporarily disabled, then you need. So towage operations also, they have their liability and they should take the liability. And These the liability, what they carry on their shoulder and what they should take. I'll tell you on the second slide. So this is the liability, property damage and business interruption, hull and P&I. So these are the coverage under port and terminal liability insurance if they are taking. And so if we talk about the liability of course will be like to who and from where. So these two areas, and also imposed by law with the local regional law plus international law which carries under the IMO Act, and as well as sometimes which is assumed under like the contract, which you have the contractual agreement, or with vessel owners we are talking about, or you can talk about with cargo owners or with stevedoring and with port authority or terminal. So those are the liability side. Now we talk about the damage to cargo. So for insurance for liability of physical loss or damage to cargo and constitutional loss, this also can cover, and then fire, impact damage, operation of handling equipment, failure of equipments, and then you have the wet damage, contamination, theft, outside, inside, temperature controlled cargo, and container freight stations. There are issues which normally handling accidents, method of stuffing containers, method of securing cargo, minor theft. These are all the points which you can read it down. So these are based on our experience. We normally day to day we receive, we get it, and these all the coverages which should be, we say sometimes the insurers or the reinsurers, they try often to take these on exclusion, and you need a smart intermediary to work for your cause, to fight with the insurers that these are the coverage normally which should be covered and due to the obvious reason. Now liabilities in relation to cargo liabilities for physical loss or damage to property or death, bodily injury or illness, constitutional losses, claims in respect of removal of cargo, container, trailers, handling equipment, additional cost and expenses incurred by a member in complying with an order from any authority with regards to removal of cargo, container, trailer, handling equipments, claims by any authority in respect of quarantine and disinfecting, or fines and other financial penalty, personal injury. So this covers all in P&I. So this is very important for also the port operator in their perspective, that once they take the P&I covers, this all will go under these liabilities. And further even, there are standards covers which, the standard covers includes these liability under the P&I again on the perspective of the port operators, the liabilities for loss of or damage to cargo and customers' equipment and ship, or loss of or damage to equipments, including loss due to strikes, riots and terrorist risk, liabilities arising from errors and omission, including delay in unauthorized delivery, third-party liability, including impact and sudden accidental pollution, fines for regulatory breach, including, example, customer pollution and safety at work, wreck removal cost, investigation, defense and mitigation cost, disposal cost following an accident, or quarantine and disinfection cost. And under the P&I, also the property covers include the building, docks and wharves, berth, buoys, jetties, dolphins, machinery, handling equipment, straddle carriers, crane, reach stakers, top lift, forklift, ship loaders, elevators, conveyors. So all those assets which are along with the properties there, which is integral part of the property, those assets belong. So to conclude, as I said, like there are plenty of options for buyers, but beware of the long-term implication, which is very important. And the current market conditions are now causing insurers to think again about long-term policies, because understanding the liability of port operators for different types of scenarios is imminent, as every jurisdictions have varied admiralty law, which will not cover one common policy wording. We should understand, and intelligent professional insurance brokers, of course, like us, can help identify and quantify risk and bring them under control. They can create and implement customized solution employing the most effective blend of risk mitigation, risk transfer, and advanced risk financing. We also assist operators in understanding or quantifying and managing insurable risk exposure arising from proposed or actual ownership and operation of a port or terminal assets, including exposure to past, current, and potential liabilities. We also assess whether the insurance cover proposed for the project addresses risk appropriate for an international port or terminal operators, including non-damage business interruption. We also analyze the length of the business interruption insurance indemnity period, whether the insurance cover is compliant with insurance provision contained within key commercial contract entered into, the scope of insurance cover in respect of contract works that are the responsibility of the owners, or the adherence with the statutory requirements to purchase insurance cover. So all these things, which is more important to analyze, unlike any normal insurance where you go your medical insurance, you buy your motor insurance, is not the same. This is very complex, whereas someone technically who knows and having blessed with both side of, as we say, running a marine and have been involved in maritime, either from the law side, either from technical side, and from the risk exposure, which is risk management side. So this is a combination of these factors to work in this particular industry. So with this, I would like to thank you all, and if you have scratching your head for any questions, I'm there for the answer, or maybe the session after. Okay, so together. Okay, thank you very much. So kind of you to hear me.
Good morning.
Good morning.
I have a question for the...
Can you just introduce yourself?
Yes, Octavio Palm from Panama Maritime Authority,
Okay.
Panama Flag Registry. Regarding the tugboat or tug operation for scrap, what is the requirement you need for the cover of an insurance for scrap?
Scrap.
When the vessel have to tug another vessel which is going to the scrap shipyard.
Yeah, I got you. So you are talking about your own scrap vessels, which is towing, and then it goes to the scrap yard, or you have sold it or going for sale. Definitely, there are two factors in that, which you have to understand. Every vessel has their own hull and machinery, which are covered. But until the vessel is seaworthy, if the vessel is not seaworthy, then no insurer will touch that, because it's already scrapped and it's declared as scrapped. The second area is the liability while the vessels is being towed, and by the the towing agencies which they take it. So you carry on your shoulders two responsibility. One responsibility that, yes, even it is a scrap vessel, but then there's a cost for that, which you are going to, it's not that on a charity, you are not going to sell, giving it free, you know. The second is that on your shoulder, if the liabilities to third parties, which you carry as well, those liabilities are again distinguished into two aspects. One liability is you as the owner of that particular vessel, either you bought it on spot and taking it to your own yard, or you are taking it a scrap vessel to sell somewhere else. Until then, the ownership has not changed. So now two areas which is very important is either these tow. Normally, these tows are not, this is not your own tow. You have given on a contractual agreement to someone to tow this particular vessel. So in your contractual agreement, you should also have the liability covered. And this is the responsibility of both the joint parties. Because when it comes to dispute, in any dispute, damn care, we say, that attitude. The only thing which is, they see it very myopic, is that, yes, these are the parties, and all the parties are responsible, whether if there is an pollution which you created, whether there was, if you are going in the sea and something happens with the vessel during the towing period, the owners as well as the towing agents, those. So you should always have the cover, which will again come on the, which will be on the marine insurance side. This will be a part of marine insurance, the cover, whereas you can extend your cover, there is on the PNI, on the PNI, if you had the earlier, you can extend telling that, yes, the vessels is being scrapped and we are taking it with these particular companies with the, to scrap it to the scrapyard, and you should have also, because normally all those tow, they will have their own hull and machinery and they will have their own PNI. So you have to submit all together, because they again, double insurance is not allowed in our industry. So you have to again exhibit that they have proper insurance covers, the liability which covers, and you take it only for that particular period, which is a short-term period of that, and it will be covered with all those which I told you about, which should be, and these are modular covers which you will get it, and the insurance company will be happily giving it to you. Of course, before that, there will be a survey. Before that, there will be a questionnaires, proposal forms to be filled up. You have to give all those things, and then based on, even if the sum insured you are talking about, you have to give also the merit of the sum insured, from where this particular sum insured you brought it, because this is the vessel which is already scrapped, and in the market evaluation, because the port operation is very complex operation. And I've been involved some years back, and so I know that when it goes to dispute and dispute in the port, this is something which, or even in the yard we talk about, it takes years and years in the court, these disputes. So that's why I said, like, I would love to answer based on this if you have any questions from there. Thank you. Otherwise, if there's no questions, then thank you very much to have a patient hearing, and my numbers, we can give it to you, and anytime you require insurance, we are there for that. Thank you very much. God bless you.
Thank you, Aftab, for giving a brief but comprehensive information about the liabilities of port operators and the insurance available and their implications. Okay, thank you very much. Please give me one more big round of applause.